Masterclass webinar on human rights and the impact of COVID-19, the pandemic, and it's World Social Work Day. So welcome to that. Let's celebrate the profession. Let's celebrate all the good work that you are doing. And I'm really, really pleased and excited to welcome Robert Johns here today. Now, Robert is or was the head of social work at the University of East London and an honorary senior visiting fellow at City University London. He worked at East London and led the MA qualifying course there in conjunction with Tavistock and Portman NHS Trust. He's taught at De Montfort University as a principal lecturer and teaching fellow. Now, he's also a registered social worker with over 25 experience of statutory social work across a full range, so from childcare and youth justice and 10 years as a children's guardian, all the way through to mental health and vulnerable adults. So he's published widely in the area of social work law, and any of the students here today that are in Richard and mine session for law and social policy, we're talking about Robert Johns' books a lot. So
Wow.
You might refer to this for me as a fangirl moment. So I'm really excited.
Oh, thank you.
You're welcome. So Robert is also the external examiner for Bournemouth University at the moment, and so we're really, really proud to have him here as part of the Teaching Partnership Masterclass series. Now, I'm Tilly Lenz, and a lot of you already know me, but since we had the last Masterclass in December, I've moved jobs, so I'm now a senior lecturer at Bournemouth University. But we felt we're really all committed to the masterclasses, to bringing academia and practice closer together. So we're continuing with masterclasses, and I'd like to use this opportunity to ask you if you've got any ideas, if you've got thoughts, what you would like to hear about in the next masterclasses over the coming year. Let us know, reach out to the Teaching Partnership. This session is going to be recorded. It's going to be on the Teaching Partnership website for you to access afterwards. And we're hoping that we'll have a brilliant morning together, a couple of hours with Robert Johns to talk about human rights and the impact of COVID-19 pandemic on social work practice. Now, as always, please switch off your microphones and your cameras to enable us to run this event smoothly and hopefully have less sound issues and echoes. We will use the chat for any questions, any comments, any reflections that you would like to share. I will monitor the chat and Robert will guide us through the presentation and make space within that to have some time for your questions and reflections. And we're going to have a little comfort break in the middle because we all probably need to have just a little bit of rest from the screen. So without further ado, I hand over to you, Robert, and I wish you well with the social work skill to share a screen.
Right. Thank you, Tilia. It's great to be with you. It's a pity I can't be down in Bournemouth because I do love my trips down there, but there you go. After that introduction, I might be a bit of an anticlimax, really, in terms of you really built me up. I don't know what to say. I was just really looking forward to this fantastic guy coming to appear, and then it's apparently me, but there you go. Right, so just to say a bit about how I'm going to structure the morning. I'm focusing on human rights, obviously, which is very much my area. So I wanted to do a very brief recap on the human rights legislation as it is, and particularly the European Convention on Human Rights, and then look at that and how it cuts across with COVID regulations generally, before I then go on to spend, hopefully, most of the time, maybe just after the break, to look specifically at some interesting issues that have arisen in the context of social work. But in doing that, I will also allude to the special arrangement, shall we say, legal arrangements that have been put into place to address the COVID challenges for social work and social work practice. So this is the big moment where we all hold our breath and see if I can manage to share the screen. Hopefully. It was running a minute ago and it's decided to turn itself off, but now it should be all right. Question
we all
is,
know the feeling.
yes. Can you see that all right?
We can't see the PowerPoint yet. It's still your screen.
Right, okay, let's try another way. Let's go there. Let's try here.
You may need to stop sharing and then reshare.
Okay. Right, I think that's what I'll do. Stop sharing and reshare. All right. When Tilly and I practiced this an hour ago, it worked perfectly, but this is always the way, isn't it?
It did.
Right. Okay,
it also makes me feel really reassured that we are indeed social workers, not IT specialists.
This is this is World Social Work Day. This is not World IT Day.
Absolutely.
Now this should be working a bit better, hopefully.
Over the course of my career, I've met so many people who are very proud to be late, wear sandals, and not be IT literate. And here we are, brave new world. We can see slides now. Thank you.
Oh, good. Right, that's good. Okay, so there we are. This is the title, Human Rights in a Pandemic and Some Challenges for Social Work. I'm very much going to focus on the legal side of it, obviously, because if you talked about all the challenges of social work, we'd be here for a very long time. So, as promised, I want to start by looking at how the law is framed by human rights considerations, and particularly the Human Rights Act 1998, which is in the news at the moment, which obviously connects to the European Convention on Human Rights. And also to point out, although it doesn't quite have so much legal force, that the UK is a signatory to various UN conventions, particularly in this context, the UN Convention on the Rights of the Child. Now, just to explain briefly where the Human Rights Act 1998 is and what it actually says, because there's a lot of misunderstanding about this. So if there are any questions as we go along, please do raise them, particularly from students. Well, my understanding of the Human Rights Act 1998 was it did three things, basically. It, first of all, said that all court decisions had to take into account what the European Convention on Human Rights actually say. And as from the year 2000, when the Act was implemented onwards, European court rulings were taken as precedent. In other words, courts in the UK had to look at what the European Court had decided in order to make their own decisions. The second thing the Human Rights Act did was to say that all legislation passed after the year 1998 will be compliant with the Convention unless it was specifically derogated. I'll explain in a few moments what derogation is, because it's particularly important in the context of the COVID regulations. And the third thing the Human Rights Act 1998 said was that all legislation that was passed prior to that date was to be interpreted by reference to the European Convention. And if it was found to be not compatible, then the courts were simply to say that this was not compatible and would refer the matter back to Parliament for Parliament to do something about it, or not, as the case may be. But by and large, they did do something about it. There's some talk at the moment about revising the Human Rights Act 1998, but from my point of view, frankly, that's a bit of a joke, because if you actually look at the Human Rights Act 1998, you could probably print it on 2 slides of A4. It's not very long, and that's essentially all it says. What you have on that slide is all it's about. The fourth aspect of it, though, that it does say is that public bodies, note the word public bodies, must comply with the convention. In other words, everything a local authority decides to do and how it acts has to be compliant with the convention. It's not a huge major imposition, but the particular word that keeps cropping up in that context, which I can explain if anyone wants it explained, is the issue of proportionality. In other words, the actions you take to protect someone must be proportionate to their need for protection and need for safeguarding. It's fairly obvious what it means legally, but what it actually means in practice is difficult to decide sometimes, difficult to determine, especially in the context of deprivation of liberty and those kind of areas and mental capacity. Just to remind you very briefly on the next slide, some important principles that underlie this. Despite what lots of people say and despite what the press will tell you, the Human Rights Act does not provide a substitute constitution by which our legislation is measured. Specifically, it does not give the courts the power to override primary legislation passed by Parliament, and Parliament is still sovereign. Nothing's changed, really. All it says effectively is that the UK has agreed that all our laws and all our legal actions and all actions taken in compliance with the law will be compatible with the European Convention, and we've basically said this for a great long time. Sorry, let me go back to that slide. It keeps flicking. So the COVID challenge, just to put it briefly, is how to practice safe social work in a way that accords with social work principles and human rights, especially those rights that are enshrined in law, which is what we're really thinking about this morning. But before I do that, I really need to tell you what's in the European Convention on Human Rights, because it's absolutely critical that we understand this. So I'm just very, very quickly going to remind you what the articles are actually say, because I'm going to refer back to them. You don't have to memorize them, but I'll be constantly referring to and fro on this, on referring to particular articles. The European Convention was drawn up by the Council of Europe, which was founded in 1949. The Council of Europe has 47 members. The EU has 27. All EU members are members of the Council of Europe. As you can see, the Council of Europe is actually much bigger than the EU. And despite, again, what the press will tell you, the European Union has no direct connection with the European Convention on Human Rights. They are quite separate issues. And just for the record, I thought I'd put this quote in from the Equality and Human Rights Commission website, who actually noted, and it's perfectly true, that the European Convention itself was originally proposed by Winston Churchill and drafted by British lawyers. So let's not change it, eh? And the way it actually works is it has a series of articles, and here comes what the articles are. Article 1 is purely notional. It just says this is the convention. Article 2, which is clearly, start with the most important one, we have the right to life. And I've put in brackets that the right to life is absolute. Again, I can explain what that means, but effectively it means what it says. You can't derogate from the right to life. You can't say that we know what Article 2 says, but in this country we're going to do something different. You can't do that. It's an absolute. And likewise, Article 3 is an absolute. Article 3 is the right not to be subjected to torture or inhumane or degrading treatment. Article 4 is the right not to be held in slavery, which is also an absolute. Article 5 is the right to liberty. Here there are specific exemptions. They're pretty obvious ones, like you lose your right to liberty if you get convicted of a serious criminal offence because you get sent to prison, and so on and so forth. They're fairly obvious, but there are various accommodations that can be made in that article. Article 6 is the right to a fair trial. It says this is qualified. It obviously is qualified in this. It doesn't actually breach the principle of a fair trial. In other words, people must have access to justice. They must have access to courts. They must know what they're charged with. They must have means of redress, but it's qualified in the sense that it doesn't mean that you can dictate when court hearings are held and so on and so forth. And there's an interesting case that has been decided in the courts recently, which concerns that in the context of care proceedings, and we'll come on to that a bit later this morning. Article 7 is the principle that law should not act retrospectively. That means quite specifically that you cannot be awarded a penalty for an offence you committed 30 years ago, according to the penalties that apply today. You can only be awarded the penalty that applied 30 years ago. And some people get very cross about this because in the context of historical sexual abuse, people have been convicted of offences they committed 30 years ago, and are then given a sentence which seems, to our way of thinking today, quite lenient. But the judge's hands are tied. The judge can only award the sentence that would have been awarded 30 years ago. Article 8 is the one we all know, hopefully, as social workers. It's the right to privacy and the right to family life. And there are some exceptions to this, and we have this phrase, lawful, necessary, and proportionate, especially the word proportionate keeps coming up in the context of any kind of state intervention in people's lives. As social workers, we're all familiar with this. It's very relevant to lots and lots of case law in care proceedings, and it's relevant to in the context of current decisions made about intrusion into family life and the extent to which social workers and other people can use their statutory powers. So that article is really probably, I would say, in day-to-day practice, the most important one for social work. Article 9 is the right to freedom of thought, conscience and religion. Again, there are exceptions to that. And then we come across the most kind of current one. Over the weekend, we have the rights to freedom of expression and the right to peaceful protest. Well, that's getting a good airing just at the moment, isn't it? Right to peaceful protest. Can you go on Clapham Common and make your feelings felt about the safety of women, especially in the context of what the COVID regulations say about people getting together and allowing safe distance? We can come back to that generally, but I'd rather kind of not get sidetracked onto that just at the moment, because obviously it is a big issue which the country and Parliament are currently looking at. Article 12 is the right to marry and have a family. 13 is the right to effective remedy, fair trial. That's not quite the same as right to trial. This is more the right to some people putting things right if they go wrong. And that was relevant. If you're familiar with it, there's a seminal case which I refer to as the Bedfordshire case, where some children whose fate was, or the state of their family life was ignored for several years by Bedfordshire Social Services. I live in Bedfordshire, so this is rather a painful memory because I was around at the time. Bedfordshire Social Services, for whatever reason, ignored their plight, and they were very hasty in bringing care proceedings. They eventually did so, but when those children became adults, they sued the local authority. And they didn't get anywhere in the UK courts. Eventually, they went to European court and said they had the right to an effective remedy. They had the right to compensation because the local authority were tardy in taking any action. And they won, and established an important principle that there had to be a right to effective remedy, a right to some kind of compensation. Article 14 simply says the convention rights are to be enjoyed free from discrimination. This isn't, some people think it's a right to, it's something to do anti-oppressive practice and discrimination. It's not, it's quite specifically only in the context of enjoying convention rights. Article 15 is derogation, which I'm going to come back to, and Article 16 is, and I don't understand quite how this might apply, but so I put it in inverted commas, restrictions on political activity of aliens. I think it means spying, basically. I think it's that extreme. And then Articles 17 and 18 are kind of technicalities, really, which I'm not going to go into. That was a very, very brief overview. As you can see, there are 18 articles. There are about 13 or 14 of them, which actually have a direct relevance to things that happen. And I want to then move on swiftly, if I may, before leaving some space for questions, to look at what the general issues are to do with. Sorry, I'm just noting by and by that there were some rights added in 1952, which we do sometimes refer back to, particularly the right to education, Article 2, which was added, and there have been some cases on that. And that I've already noted that the Human Rights Act 1998 makes public bodies accountable for their actions, so you can enforce the convention against government departments, courts, prisons, police, local authorities, and NHS. Those are examples. But one issue that's arisen in practice in social work with adults, of course, is that if you place someone in a care home, which is run by a voluntary organisation or a private organisation, and that care home closes and it closes without consultation, any attempt to take legal action on the grounds it's a breach of Article 8, which it is, because there's been lack of consultation and people living residential care as if it were a family life, you'll get nowhere because if the private organisation runs the care home, you can't take action against it under the European Convention. Whereas if the local authority ran the care home itself, of course, you could take action. So there's an anomaly there. Again, if anyone wants explanation, I can come back to that. But anyway. Right, I said I'd talk a bit about Article 15, about derogation. There was some guidance issued by the Council of Europe to all countries that are signatories, all 47 countries, that says when you're thinking about drawing up your COVID regulations and COVID laws, bear in mind that some convention rights are absolutes, and that there is a procedure you need to go through if you derogate. And this is what Article 15 says. Firstly, in time of war or other public emergency threatening the life of the nation, yes, COVID might qualify as a public emergency threatening the life of the nation, any high contracting party, that's highfalutin legal language, it means any country, any state basically, any high contracting party may take measures derogating from the obligations under the convention to the extent strictly required by the exigencies of the situation, providing that such measures are not inconsistent with other obligations under international law. I take that to mean that introducing the Coronavirus Act 2020 and the coronavirus regulations is lawful if it breaches our rights to assembly, our rights to privacy, our rights to family life, and right to liberty, but only to the extent that you can justify it as being directly linked to the need to prevent the spread of COVID, the coronavirus. That's what I take that to mean, and I think, to be fair, that's what Parliament takes it to mean. And they have been quite careful up to now to make sure that you understand, or we understand, that they're only doing what's absolutely necessary. Although we might have issues with how they actually present that, but that's another issue. You cannot derogate under any circumstances from Articles 2, 3, 4, and 7. That's right to life, right to humane treatment, and the right against slavery, actually. Any high contracting party availing itself of this right of derogation shall keep the Secretary of State, Secretary General of the Council of Europe fully informed, blah, blah. I'm not going to read that all out. Basically, what it means is if you're going to derogate, you've got to tell the Council of Europe that's what you're doing. And in other words, you have to justify it. So that's where we are. That's the broad overall structure in terms of the European Convention and where we're at in terms of how you can override, as it were, for a short time, to the extent that's necessary, people's fundamental human rights. I'm now going to talk a little bit, or just highlight for you very quickly, some of the issues that I think arise. We could go through these and we could all add, I'm sure, to these, but I'm just going to highlight some of the articles where COVID regulations, coronavirus regulations, coronavirus laws, what you like to call them, actually impinge on the articles. Right to life. Well, in essence, that's the whole justification, rationale for having the Coronavirus Act. We are protecting people's lives. We are accepting that the state has a duty and obligation to keep people alive. Therefore, we are promoting the right to life. The extent to which we do that, is obviously an issue that has as it were, been of concerns to the court, because what do you do if there's a question of people of ending people's lives, where in circumstances where that either medics say there's no particular point artificially perpetuating life, and so on and so forth. There's a number of different cases about that. There's a fair amount of case law on that, and I'm sure you're probably already aware of it. But that's in essence what the whole thing's about. It's about right to life and protect it. So the question for us is how to maintain the balance, between the right to protect people's lives and also what to do if that conflicts with the right to liberty. If you tell everyone to stay at home and never go out at all, you'll obviously keep them safe in the sense, but you'll stop them living, because they can't then go and shop and they can't do things that are absolutely essential. But as soon as you do the things that are absolutely essential, you do actually, as it were, to some extent, threaten other people's lives. So that's maintaining that balance is in a sense what all the legislation, coronavirus-related legislation, has been about in the last year or so. And boy, it's been a long year, hasn't it? Right. So the right to life is an absolute, but at what cost is the issue, really. Article 3, no one shall be subjected to torture or to inhuman or degrading treatment or punishment. Well, the issue I think arises here generally is, what about people being detained for an excessively long time in solitary detention in psychiatric hospitals and prisons? There is a point at which that becomes inhuman. We don't have constant solitary confinement, but not allowing people out of their prison cells, not allowing them out of hospital wards, so on and so forth, at all for days on end, especially if they're young people, seems to be getting towards infringing that article. The other issue that's arisen, of course, is what happens when detainees are forced to share, especially with someone who may be particularly vulnerable to COVID. I don't have answers to these questions, but these are the issues that arise. And specifically, what happens, how do we address the issue of young detainees held for lengthy periods without access to education or an independent visitor? And here I've noted that the United Nations Convention on the Rights of the Child also applies, because that's very clear on the right of young detainees. So we're talking 12, 14 and 16-year-olds, their right to education. Which at the moment, as far as I can gather, is in some institutions actually being denied. It's unsafe to provide it. Well, it raises issues. Article 4, right not to be held in slavery. I don't want to say very much about this, just to note that obviously we do have the Modern Slavery Act 2015. But the issue is I am, I'm sure other people are as well, suspicious that there are acts of modern slavery now being perpetuated that would not be detected simply because people don't have the means of detecting them. Either police aren't available, or they can't go into particular accommodation to check things out. And of course, people who are enslaved, as it were, you can justify the fact they don't go out at all, because no one's going out at all, because we're all told to stay at home. So the issue is how to actually enforce that particular act, which in principle is a very good act. Article 5, right to liberty. Well, this is the big one, isn't it? It's routinely now overridden. We're not allowed to go out and to meet friends, even to see relatives in care homes. We're not allowed we're encouraged to stay at home, and that's obviously directly infringement of our right to liberty, but it's justified because don't forget, this is not an absolute right. It's justified on the grounds that we are going through a period where there's a threat to other people's lives, everyone's lives. There's a threat to health. I should point out that this has led to an automatic assumption that controlling the epidemic trumps everything, and therefore it's okay to override the right to liberty. It's not quite what the European Convention says, but we could have a long debate about this, and it is a very real issue. Just to remind you what I think the Convention says, I think what the Convention says and the derogation principle says is that you can impede the right to liberty only to the extent that it's directly related to the need to prevent the spread of the coronavirus. I'll leave you to decide whether that's exactly right and exactly what's happening at the moment. Article 6 is right to fair trial. The issue that arises here, and I do want to come back to this because it's very important for social work, is that court hearings are being held virtually. In other words, like this. Well, how would you feel if this was care proceedings and I was the judge and you were the parents down in Bournemouth, I was here in Bedfordshire, and I was deciding about your case by assessing your character by a screen? I'm not sure about that, but that's what's happening. There are limitations on calling evidence. Incidentally, that's not entirely true. Not all court hearings are held virtually. There are some live court hearings, but very limited. There is delay in proceedings. Inevitably, there are court staff not available because they're isolating and so on and so forth. And so there's big issues, and I'm going to come back to Article 6 big time. Article 7 says there's no retrospective laws. This is tricky because there's limited potential for challenging the validity of law and the penalties for breaches, and that is proving quite controversial in terms of fines being imposed and people wanting to challenge them, and there doesn't appear to be any right of legal redress. And we've now got to the stage where even the judges are getting confused about what the law actually says. And as for the police, they keep being damned as they do and damned as they don't, which I think is probably a fate that's familiar to social workers in the past in child protection. You're damned if you do and you're damned if you don't, but there you go. So there we go. But just to remind you that this right is an absolute right. Article 8, right to privacy and family life. Well, COVID regulations are very, very intrusive. And particularly in the context of social work, what about restrictions on visiting family members? People are very, very upset about the fact that their right to visit people in care homes is restricted. But it goes more widely. What about the rights of prisoners to see their children and children to see their parents who are in prison? But also in the social work context, what about rights of children to see parents when they are in foster care, or and so on and so forth? And also the other issue that's arisen, which the government have tried to resolve, is that of split families where children live with one parent and the other parent has access, has a child arrangement order, what have you. So that's a big, big issue for social work. Children deprived of parental contact, and the long-term implications for that, goodness knows what it is, but that's a big issue for practice. And as I just said, children who are in custody, sorry, not the parents in custody, but where the children are in custody, they're not getting visited by their parents, which seems to be a fundamental breach of their rights. As you can see, there's quite a lot of these. Right to freedom of thought, conscience, religion. Well, closure to places of worship, of course, directly contravenes this, but of course this one isn't an absolute right, so you could justify that on the grounds that there's a overriding public health concern. And also Some people are talking about making vaccination compulsory, but actually, if you look at what the convention says, you can't make vaccination compulsory, even though some of us might agree to the principle. You can't really do that. People have the right to say that, even when they're completely misguided, that they disagree with vaccination. Article 10 is right to freedom of expression. And here now we're grappling with what you do when people are trying to kind of undermine public health campaigns to get people vaccinated by spreading false information about the effectiveness of vaccinations and the dangers it implies. And that obviously is the challenge, because under the convention, people have the right to freedom of expression, so they can say what they like about how effective the vaccine is, even if it's untrue. So how open is the debate about intrusions in the lives of individuals? That's the question that I'm raising there. Well, right to peaceful protest, we know all about this one. The real danger here is the complete suppression of legitimate protest. You're really angry about something, you apparently can't do anything about it. Well, that clearly is a contravention of Article 11, but you can justify it because you can say that if people do get together and protest, by definition, it's an assembly. You can't have more than one family getting together, therefore you're in breach of the regulations, therefore you'll get rounded up, and so on and so forth. That, as I say, is a very current issue. But I just point out, my point 3 there is that I think we have to be very alert to the risk of ceding, as I've put it, unparalleled power to the executive. In other words, are we going to give up all our rights to protest because we want to protect people's health? Article 12, this is interesting, right to marry. But initially I thought, no, I can't really see how this is affected by COVID. And I thought, well, yes, because there's now limitations on basically getting married. Weddings are only allowed in very exceptional circumstances. There have been repeated postponements, and well, yes, that's an issue. It's not really a social work issue, but it is an issue. Article 13 isn't more of an issue with social work because there are now, in practice, severe restrictions on access to legal assistance. Some advocacy agencies have been compelled to close. You can't access information if you're desperate for legal support, and this is obviously very relevant in the context of domestic abuse. The agency is not available, you're on your own, and people are suffering. I don't have any doubt about that. It's a real serious issue. We will see in a few moments after the break, when they get onto legal cases, that this has been a particular issue with a parent who complained to court that they could not have access to the lawyer they wanted in court to in a care proceedings case, which had real implications for them. Right, Tilia, I want to stop there because I need to take a breather, but I think there might be some questions. So over to you.
I'll start from the bottom up. There's weird echoes. Anyone with the microphone off? Could you please switch it off? Let's try again. Can you all hear us fine? We'll see. So starting from the bottom up, Chris, Kit, you raised an issue about birth linking to Article 12, that actually partners aren't allowed at the birth at present, which is a real dilemma for families. And I just wanted to share a little story that my student was involved in, where she had been working with a family where a young person, aged 16, had just given birth, and her family wasn't allowed to be there. Her mother wasn't allowed to be there, nor her partner. And the social worker, in fact, was the first person who visited after she'd given birth. That was a real ethical and moral dilemma that we had to unpick and put her in a really difficult position. where we both agreed maybe there are some situations where that is just very, very harsh. So Chris, thank you for raising that. And I think with that we've probably come up with some issues where Article 12 is impinged and how it relates to social work practice to some extent. Now, another situation was raised by Sharon. Thank you for pointing that out. You had a case where a lady was admitted to an interim care home from hospital under COVID funding, and she wanted to return to her own home, and a package of care had been arranged to start, and a start date was given, but then the care home had cases of COVID and she couldn't go back to her own home. She couldn't leave. So that is a really tricky one if we are dealing with situations where a package of care has been agreed and people are stuck.
Yeah, my argument was that she had capacity to decide, and we are detaining her against her wishes. The council policy was at the time is that we cannot discharge people where there's a risk that they might be spreading COVID into the community, and the care home were quite clear that Public Health England told them that she could not leave because they had cases of COVID amongst their staff and residents. So she had to stay there until that was clear. So yeah.
Wow.
We were trying to keep the package open, you know, obviously, because then you've got to try and source a new package of care for when she was capable to leave. We didn't know when that would be, all manner of issues. But yeah, I was told that coronavirus legislation trumped her human right to leave that situation with that detention, for want of a better word. So yeah.
Robert, do you have any views on that?
That's always the argument you come across. Coronavirus legislation trumps everything. It would have been an interesting case to test out in court. I think the courts would have put a lot of pressure on the agencies or to say, well, you have to facilitate her coming home. If she has capacity and you can provide a package of care, you have to have a plan to actually do it, I think is what the courts would probably have said.
And that was my argument, but I was told council policy is we can't, you know, council policy says we can't risk it spreading in the community, and I was saying, but we're you know, contravening her human right to go home, and she has capacity and she's, you know, keen to go, and we are also putting her at risk of catching it in an environment where it's. You know, that's what I was really worried about. And if she were to catch it and die and her family were to sue the council to say, you know, your policy's rubbish. But then I was told, then when in the care home, I said, no, well, you know, let's try and facilitate it. And the care home said, no, Public Health England absolutely told us we cannot release her. So that's what we went with. But I agree with you. I think it would have been very interesting to challenge that in court.
Yes. Yes, I mean, I have to say that the few cases that there have been is that the judges would probably go with what Public Health England say. But anyway, I can't prejudge it. I don't know, but it would have been an interesting case to test out.
Another question that had come up, or a comment, was around the right to life and how it can be an absolute right when the police, as a public body, can be armed and sanctioned to take life. Now, I think that comment was then put into the context of the derogation which you explained, and Richard raised that point as well, that he's now realizing that derogation explains the whole situation, that we, in a sense, need to balance it.
Yes, it's to be fair, the police do not have the right to take life. That's an absolute. The police only have the right to defend themselves, which is specifically allowed under derogation. Thank
you for clarifying that. Now there are some, let's say, practice descriptions really about the case that Sharon raised about if the lady that she was working with could have been in isolation for 10 days and had COVID tests and all the rest of it. So I will leave those comments to be running in the background because there seem to be a good practice debate where people can learn from each other and share ideas and experiences. So I think we can move on from there. Thank you everyone for questions. So if you've got any more questions, comments, put them on there, and when we'll have a breather for Robert, I can look through and post them to you, Robert. Thank you.
Yeah, sure. Okay. So I make it 10 to 11 now. Shall we say 10 minutes? Does that be fine? Yeah.
Fantastic. So we're going to have a 10-minute comfort break.
Yeah, and ask people to be back for 11 o'clock prompt, please. Yep. And I'll start.
So I will keep the recording running. So if you want to put questions in the chat during that time, any reflections, you're more than welcome, and I will collect them, and we'll see you back at 11 o'clock for the second round. Thank you very much, everyone. you wanna switch off your camera?
Sorry.
All right, not a problem. We'll start again in a minute. I'm hoping everyone was able to refresh themselves, have a quick comfort break, take their eyes off the screen, and get another cuppa. Welcome back, Robert. There we are. Cheers.
Cheers.
Happy Social Work Day to you.
Yes, and to you.
This is very social work. It's even a herbal tea, so.
Oh, well, there you go.
I'm ticking all the boxes for stereotypical social worker today.
Yes, I saw someone made some comment about sandals. Like, what are they?
Well, I think there are very few people who are wearing shoes these days at work.
No. Well, there you go.
Okay, now it's 11 o'clock. A couple of people had to leave us due to other work commitments, but as we said, this is going to be recorded and is going to be on the Teaching Partnership website. The link for that is already in the chat. So let's come to the second part of this masterclass with Robert Johns. Any questions, any comments, please put them in the chat and I will monitor this to ensure that they're going to be answered later. Over to you, Robert. Thank you.
Right. I now have the technical challenge of trying to get the presentation to load again. Let's see what it's doing. Here we go. It's doing something, but as usual, it's taking its time.
We can see the PowerPoint. We're back on page 1.
Yeah, I know. I'll just run it quickly through to where I think we should be. One of the things I have to get used to in Teams is that I don't, which is very frustrating, is I don't see exactly what you see. And it's a kind of bit of a weakness of it, really. This is a very quick revision for you. It's going to have to go through every single slide, but we will get there.
They're all quick readers, I'm sure.
Sure. I don't know, incidentally, Tilly, would it help if I actually sent you that we have got the presentation? I don't have any problems if people actually want to access it, but can I please ask people to note that it's really for their personal use? I don't really want it going everywhere. If you see what I mean.
Absolutely.
But if you signed into this session, I think you're perfectly entitled to have a look at the PowerPoint, and especially when we look at some of the case decisions coming up, because there's some detail there which I haven't really got time to go into, and you may not want me to go into because you need the principles of what's been decided.
Yes, there is an appetite for the slides, and I'm sure our students would very much appreciate it.
Right. Okay. What I'm going to do in this part of it, I must make sure I get time to cover both aspects of children's work and adults, because to be fair, you should have in front of you a slide that just summarises the changes in relation to children and families.
Yep.
Yep. Okay.
Perfect.
The way Teams works, it's coming across as quite small to me, but anyway. Just as a summary, the Adoption and Children Coronavirus Amendment Regulations of 2020, it's a bit of a mouthful, isn't it, consist of 10 sets of regulations. They affect aftercare planning, fostering, residential and adoption. The regulations are primarily, I think it's fair to say, about timescales, allowing flexibility in terms of when visits have to be carried out, how they have to be carried out. Specifically, what's allowed is virtual visits. You don't actually have to go and see children. You can just talk to them by Zoom or whatever, or by phone, or just phone them up. So that's one aspect, and obviously there are a number of social implications for that, but I'm really focusing on the human rights aspects. There are also relaxation requirements for education and healthcare plans, and specifically, and I know people have been concerned about this, about relaxation in terms of the concerning special education provision. But as such, both those sets of regulations don't have direct connection to human rights conventions as such, but they do have a lot of longer term implications. While you're welcome to have a chat about that and go into that, I think I want to focus, if you don't mind, on things that are specifically to do with the courts and what they've had to look at. Right. The major change that I think directly impinges on the European Convention is the changes in the operation of courts, especially in relation to care proceedings. And also the other issue that is related to that is about child-parent contact, which clearly connects to Article 8. As I alluded to earlier, the courts are assuming or taking a default position that most hearings are virtual hearings, but they have accepted in care proceedings that's not always appropriate. So they have also allowed what they call hybrid hearings, which is where, well, it's a bit like Parliament, where there are some people actually there and lots of people communicating virtually. So, for example, you might have a judge and one or two lawyers in court, and a witness, some witnesses actually physically in court, but everyone else is online somewhere. There are 3 cases that have directly addressed the issues that relate to that and coronavirus. And I want to say a little bit about each case. I want to give you a summary of what's happened, and so we can then explore this just a bit if time permits. The first case I want to look at is referred to as Race C, Children COVID-19 Representation. It's a 2020 case. It was decided by the Court of Appeal, and this is what happened. I think I alluded to this earlier. This is a case where the parent got very upset because their lawyer couldn't be in court. The leading counsel, this was the barrister, was required to be absent. They're required to shield under the COVID-19 regulations, so they couldn't actually be in court to provide support. They couldn't be in court to cross-examine witnesses, and the parent was so upset that they actually raised this issue with the judge, and there was a judgment made about it, and it's quite a detailed judgment. And what's significant about this for our purposes this morning is that the judge was very preoccupied with Article 6 and the right to a fair hearing. And having looked at that and looked at what the requirements are, and then contrasted that with what are the wider considerations, because obviously Article 6 isn't an absolute, said that it isn't unfair for the advocates to be absent because they have to be under the coronavirus regulations, but they can still carry out their job because they can still cross-examine witnesses, albeit have to do it remotely. And the actual judgment said, and I quote, "There is no reason to downplay the effectiveness of remote examination and cross-examination by a skilled advocate." I'm not absolutely convinced by that. I think there is something to be said for having advocates and witnesses actually in court. But of course, you can ask the same question. You can ask it in the same way, assuming your connections are up and running. My problem with it specifically is, of course, that some of the effectiveness of cross-examination is that people are, well, a social worker is familiar with this. There's a lot to be said for non-verbal communication, is there not? You don't get the non-verbal communications to the extent online that you will get live. So a virtual communication, yes, you can say the same words, you can almost say them in the same way, but can you actually reconstruct virtually what you can reconstruct in a court setting? I think the answer to that is no. But however, in this instance, the judge said, well, yeah, the lawyer can do effectively what they could do in court. So there you go. I think there was already a comment on that. Can we just ask what the comment is, Tilia?
Yes, Neil has raised that this judgment goes against the judgment that was made in the Devon partnership in a case in January, that under the Mental Health Act, AMS and doctors must interview the patient in person and not remotely.
Absolutely, and that's, yes. So it's a bit odd, isn't it, that you make one kind of decision in mental health cases, but something else in another. I mean, I suppose the only difference is that in the mental health assessment, you are making a direct assessment about whether someone should be deprived of their liberty. And deprivation of liberty is under the convention an absolute. Right to liberty is an absolute. Well, it's not entirely, but there are some qualifications. But you wouldn't be fulfilling the requirements of the Wintervert judgment. The Wintervert judgment is the European judgment that says that in order for detention to be lawful on mental health grounds, there has to be a proper assessment by competent people, and therefore the competent people have to see the person. And seeing the person means seeing the person. And actually, in fact, if memory serves me correctly, the Mental Health Act requires the approved mental health professional to actually interview the person. I don't think it ever envisaged interviewing them remotely, and I don't think you can really get away with that. But here we have a judge looking at Article 6 who says that I think a lawyer can conduct a reasonable cross-examination at a distance through remote means.
Robert, there was another comment that was made by Wendy, who asked, how has the amendment to the legislation impacted on practice standards for statutory visits, especially in relation to child protection visits?
It hasn't, as I understand it, affected directly safeguarding such in terms of section 47 of the Children Act 89. The amendments have been is more the longer term. So, for example, if there's a requirement to visit a child in the foster care at certain frequencies, those have been relaxed. It's those time spans and particularly in terms of how you carry out the visits, the expectation obviously used to be that you actually go and see the child in person and go and see the foster carers in person. That's been specifically changed so that you can actually now stay and sign off as having conducted the visit by doing it remotely. I mean, it raises, particularly in context of very, very young children, it raises the question of how you can actually say you can do that. But there you go. That's what the regulations say.
Thank you.
Right, I'll move on. Right, the next judgment I want to look at briefly is Lancashire County Council and M, which is a concerning and adjournment. This is quite an interesting case. It's quite long, so I'll try and summarise it for you. England and Wales Family Court is what EWFC stands for. As you know, this is the way that this gives you the source of the case. So if you ever wanted to look these judgments up, you could literally just put EWFC 43 in Google and hopefully the judgment will come up for you. Although I should warn you, it's quite a long one. This is a serious abuse case. In 2018, October, there were very serious injuries to a child, and if you look through what the injuries are, you'll quickly conclude that those injuries could not really have been caused accidentally. Explanations were required, so not surprisingly, care proceedings were instituted, and the final hearing was due to take place in March 2019. And during the final hearing, the final hearing had to be stopped because the father was taken ill and rushed off to hospital, and the case was adjourned to October, actually. The father didn't attend, and there was a decision made that he couldn't attend without the assistance of an intermediary, has a serious psychiatric problems. And the psychiatric report confirmed that although he had capacity to instruct solicitors, he was suffering from recurrent depression and moderate severity, and he needed someone to assist him. He needed an intermediary. And that was the conclusion. And then moving on. They actually got to the final hearing in March 2020, an auspicious date. Parents were there, but the father had his intermediary. And then, of course, problems with COVID started. The judge, reluctantly, I think, decided they had to adjourn the case because they couldn't ensure that staff in the court were safe and that everyone in court was safe. And particularly in the context of the case was heard in Preston in Lancashire, and it was a very small room and everyone was close together, and the judge said, I can't carry on. Decision was then made to transfer the court to Manchester, I think it was April. The parties could not agree about a remote hearing. The parents were saying, no, we actually want our time in court, actually want to go to a court. And the court had to then consider this and said, well, in terms of Article 6, we don't want to have a remote hearing if the parents object, because then there's a possibility of appeal. And then quite rightly, they could argue that under Article 6, they had the right to a hearing in court where they could cross-examine through counsel the witnesses in person in court. And therefore, the court concluded we can't do this case remotely. So what do? We go to Manchester, which is obviously some distance from Preston. And there, the court's much bigger. People can stand the required 2 meters apart. We can have a socially distanced hearing. Great. But then the father said, but I can't get to Manchester. Right? He said he had to participate properly in the court hearing, and he wasn't in a fit state in terms of his mental health to actually travel there, but he couldn't provide any medical evidence to prove that he couldn't travel there. So what is the court to do? Well, the interesting thing about the case, and why I do commend, I mean, if this is a real issue for you, do have a look at the case in detail, because there's a long kind of lengthy consideration of various aspects of the Children Act and the COVID regulations and everything else that impinges on this. And particularly what preoccupied the judge was the obvious requirement in terms of putting the child's interest first, which is Section 1 of the Children Act. I'm glad he said that. He'd be a good social work student of mine, because that's what my social work students would have reminded me straight away. And then, of course, there's the requirement to conclude care proceedings within 26 weeks, because they're already in breach of that. They're having real problems keeping it within the time frame, and that's obviously the requirement that was added to the Children Act 89 by the Children and Families Act 2014. And then, of course, there's national directions to family courts and the present family courts guidance and so on and so forth. There's also other hearings about it which have pointed out that when you're talking about care orders and placement orders, it's really tricky to talk about those as remote hearings, because they raise such fundamental issues about depriving parents of their rights to look after their own children. And obviously in placement orders, you're effectively going for adoption. And the President of the Supreme Court has already said that adoption, effectively in the context of placement orders, is about the most serious order a court can make. And she means that. She means including life imprisonment, because effectively you're actually changing things fundamentally forever. So what's the decision? the judge says he's not going to refuse the application to adjourn. He's not going to agree to the father's request that we all have to wait till Sunday when we get back to Preston, because the court has made provision for a face-to-face hearing, and that complies with the guidelines. The local authority is prepared to fund a taxi for the parents to get to court. Imagine the implication of that for the budget, but never mind, that's what they had to agree to do. Delay would cause an impact on the child's welfare. We're back to Section 1 of the Children Act. And then, of course, there's the evidential issue. There's the issue about, but if you're going to have yet another adjournment, we're going to get to the stage where people genuinely can't remember what happened. And we need to go and have this court hearing because there need to be some findings of fact in this case. If you remember, the case started with some very, very serious and unexplained injuries to a very young child. Then point 5, if the parents refuse to attend face-to-face hearing, you can have it as hybrid. They could stay in Preston. You could have the rest of the hearing in Manchester. You could communicate between the two effectively. And then point 6 is quite interesting. Whilst there will be some cases where it is important for the court to be able to see the parent in the courtroom itself, the credibility of the parent's evidence is to be evaluated primarily by reference to matters such as the internal consistency of their evidence, its logicality and plausibility, details given or not given, and the consistency of their evidence when measured against other sources of evidence. Bear in mind that this is a case where effectively one or other parent is really accused of seriously injuring their child. For care proceedings, you don't have to establish which one it is, but clearly, in terms of the circumstances of the case, one of them must have done it. But the judge has said, well, actually, you could decide that with them not being physically present in court. Again, we could have a debate about that. So neither parent will be denied a fair trial if required to give their evidence remote location during the course of a hybrid hearing. I mean, trial is unfortunate to use. It's not really a trial, but I suppose the way that they would perceive it, they might very well think that it is. Any questions come up about that case, Tilly? Or can I just...
Not that I can see.
Okay, fine. Yeah, we can come back to that because it's a really interesting case. And should I just carry on to the next one, because this raises different issues, and obviously I'm looking at the time and bearing in mind I do want to talk about adult care as well. So let's go on to the next case, which is about contact. This is about a parent's contact with a child who was actually in care, and what happened in this case, this is a Court of Appeal case. So someone's asked what the outcome was. Of course, I don't know. That's the problem. The problem with all these cases, my students used to get incredibly frustrated. You're thinking, yeah, you've explained all the case, you've explained legal judgment. Where does it go from there? And of course, don't know. Sorry. Okay, this case is an appeal and care proceedings because a mother wants contact with her children in local authority care. The children are placed with her maternal grandmother. Again, it's a serious abuse case. There was a leg fracture, which is possibly inflicted by the mother, but there's no proof of that. Before March 2020, an auspicious date, contact had taken place 3 times a week for 2 hours, and it was supervised by the local authority. But then the contact centres closed. So we go over to videos. But we've got very young children, and that really wasn't felt to be satisfactory. So mother asked the local authority to re-establish face-to-face contact, and the local authority refused on COVID grounds, and the judge said, you have got to make a statement and we've got to have a hearing about this. You can't just refuse on COVID grounds. It's not good enough. What's your plan to re-establish face-to-face contact? Because I say that these children are entitled to see their parent face-to-face. And of course, the judge is absolutely right on that one. And then, of course, we get into, this is where the government guidance keeps changing. We can have small groups from different households, but then the local authority said, yes, but the requirement is you observe social distancing, and we're talking about a 3-year-old and an 18-month-old, and they don't know about social distancing. They won't be able to observe it, so we're not happy with that. And move on. So then what happens is bubbles are allowed. So mother goes back to court and asks for an order. So I'm going to go in for a bubble with my own mother, and we can go to a local park, and you can supervise it. And then the judge said, "Okay, I'm not going to get involved in this anymore. The local authority can decide about this. I think that's okay and reasonable. I'll leave it to the local authority." And the local authority then took the view that we're only allowing indirect contact. And the mother said, "I think that's wrong." And the mother then appealed the judge's decision, and we now go to the Court of Appeal. You can see how this can get quite complicated, and this is just one issue about one parent having contact with a child. So here we have the Court of Appeal. The court said, obviously, during a pandemic, especially for very young children, it is particularly difficult for them to lose contact with a parent. And everyone should put out the stops to try and remedy that situation. I think as social workers, we all applaud that decision. Of course, that has to be right. But the court then said contact arrangements have to be assessed on a case-by-case basis. The court said local authorities obviously under a duty to allow reasonable contact. That's what section 34 of the Children Act 89 says. Obviously, this child's under an interim care order. Must promote contact. That's in the schedules. Child's welfare is paramount consideration. That's point 2. Obviously, that's section 1 paramountcy principle. And there's also the welfare checklist referred to. And it's not, and this is where the Court of Appeal differed from the judge. The Court of Appeal said it's not really down for the judge to say to the local authority, you decide, you get on with it. The court has to make its own decision. You look at what the local authority is saying, but then the court can come to a different view. And the judge is therefore wrong to say it's only a question of whether the local authority's position is reasonable. It's the judge is under a duty to make sure that section 34 is implemented, and they can make a judgment about whether it's reasonable or not, if you see what I mean, and also can override the local authority and say, I as a judge order you to make contact in a particular form or particular way. Right, the court then commented that in order to make a view about this, it needs information about the child's situation and, of course, about local authority resources. They're not infinite, and the current government guidance. And on the basis of that, the court said, it's double negative, I'm afraid, it couldn't support the conclusion that no face-to-face contact was possible. Therefore, what the judgment says is, the local authority must facilitate face-to-face contact. It's essential. And in a sense, Article 8, by implication, does override some of the health issues that local authorities seem to be preoccupied with. So, although I've noted here, it's in italics because it's my comments, it's not from the judgment, the court didn't explicitly address Article 8. It did in effect, because it's talking about the rights of parents and children to have communication, have reasonable contact, and have meaningful contact, which is, I think, the phrase I would add. In the context of very young children, the local authority was taking the position that the contact was reasonable, but the Court of Appeal was saying, well, we don't think it actually is, and you'll have to, as it were, put the Children Act 89 Section 1 requirement and specifically Article 8 uppermost, and you have to take those as more important to some extent than the other issues that you've raised in terms of COVID. Obviously, you can't breach the COVID regulations, but there must be a way in which you can get around all of this. And I think basically the local authority did do that. I think they went through a period where the regulations changed anyway, so that the problem resolved itself in a sense, if you want to know the outcome. but it's an interesting one, and I think it does give us, or give social workers, some kind of guidelines. Are we okay? That's the end of that case, and that's the end of the cases on children and families that I want to look at before I move on to adults. So briefly, any comments?
No questions, and just raised that there are similar issues in residential care homes for visitors with older people. So that probably very nicely guides us over to adults.
Absolutely right. Okay, let's go on to that then. Okay, the adults issue with adults. Right. Again, I'm going to start by reminding people of what their regulations say, or rather did say. In the context of mental health, this is very interesting. There was a regulation passed last year that said that in future applications by approved mental health professionals for Section 2 or Section 3 detentions could be based on one medical recommendation instead of two. There was an extension, doctors and nurses holding powers, and there was relaxations of the medical recommendations required for the court-related detention orders, which are all those ones you see listed there. And there was also, to my mind, slightly worryingly, relaxation rules concerning second opinions in compulsory treatment cases. And also there were relaxations of the time limits for police detention powers. So it's ironical, really, because Section 135, 136 used to have a maximum of 72 hours. That was changed 2 or 3 years ago, reduced it to 24, and now the regulations increased it back to 72 hours. What's interesting about these regulations is they were never enforced, and recently the Secretary of State for Health has announced that he's not planning to renew them. Well, recently in September. He was supposed to renew them in September, but he decided not to. He said, I've been told that we don't need these rules, that the health authorities and approved mental health professionals do have some problems in complying with them, but they would rather stick to the rules as they are than watering down these rights. And I applaud that decision, because I think it would have raised issues about the extent to which you could really comply with the European Convention. We also had some changes to the Care Act, and these are more controversial, although there's not any human rights implications as such. What was controversial about them is all the duties that people applauded in the Care Act: the duty to assess service users, the duty to assess carers, determination eligibility criteria, and so on and so forth. All those were changed from duties to powers. In other words, local authorities could, if they decided to, they actually had to declare it. If they decided to, they could, as it were, remove from themselves the obligation to conduct assessments and some things in relation to care planning and choice of accommodation and so on and so forth. Interestingly, only 8 local authorities actually implemented this and said they were going to do it. They all did it for quite a brief period, and they've all actually gone back and said they are going back to implementing the Care Act as it said. They do now have a duty to assess and so on and so forth. What, of course, was interesting from practice point of view is the duty to conduct a financial assessment was withdrawn, and we had that kind of blissful period where people could go and could have care provided without so much concerns about financial situations. I'm afraid those days are now gone as well, but there you go. Right, and the other change, of course, was the implementation of the liberty protection safeguards was delayed until April 2022. So we're still with the deprivation of liberty safeguards. If this doesn't mean anything to you, it's to do with the provisions for authorising detention of people who've lost capacity, who are in care homes or in hospitals and are kept there effectively against their will. What's more of an issue from that human rights aspect is the fact that court protection moved to remote hearings, and there's been a delay as a consequence in terms of getting cases heard. However, there have been some cases heard, so we're going to look at what some of those are. The first case I want to look at is NG, who was represented by the official solicitor, as people often are when they don't have capacity to conduct litigation or instruct solicitors. It's against Hertfordshire County Council. It's a Court of Appeal case, and it's very recent, it's 2021. And this is to do with the regulations. If you remember, the regulations were so strict that it actually stopped people leaving home altogether. And in this case, NG's parents weren't allowed to leave their home to care for him. In fact, as I understand it, that's kind of a misunderstanding of the regulations. I think if it was to provide care, they could have left their homes. But anyway, that was the issue. And it was held that the parents' help was essential for him. And the judge decided that they weren't allowed to do that because they weren't the main carers, was wrong. What's interesting from our perspective this morning is the court had a debate with itself about the extent to which the regulations interfere with Article 8, but then said, and I'm sure this is correct, the regulations could impede Article 8 because they're covered by the emergency health exception allowed for in the European Convention on Human Rights, which we've talked about earlier. But what's significant about the case is the fact that although NG was receiving care in one place, the parents were providing some additional support of care and support. And the judge said, don't think that's the correct interpretation, so you can't do that. I say it's essential, therefore you can do it. The other case I want to look at is Clark and London Borough of Hammersmith and W. This again is a very recent case. It's Court of Protection. This is vaccination, coronavirus vaccination. This is the son objected to his mother being given a vaccination against coronavirus. Consequently, when everyone in the home got together to have all their vaccinations, she was told she couldn't have hers because her son objected. She doesn't have capacity to just make medical decisions for herself. So there's an application to the Court of Protection to make the decision for her and to override the son's objection. So the GP is asked to do an assessment, and that's quite interesting because it was clear that Mrs. E would say to the doctor, well, I think you should do whatever is best. And she kept coming up with that phrase, whatever is best. And although she didn't really have capacity to this decision, in the sense that phrase is quite significant. In other words, she was compliant. If you said, it's in your best interest, Mrs. E, to have a vaccination, she would go along with it. The court also took into consideration what it could ascertain from her previous views. She previously accepted the flu vaccine. She says that she'll do whatever is best. This is where we're in difficulties because the son is quite articulate, and he says and argued with the court and said, but this vaccine is untried and untested. No one else has had it. And the court said, well, no, because your mum's in the top priority group. They're the first group to have it because they need it, but it's been tested. And he said to the court, well, I agree to having it, but later. And of course, but there are already cases of COVID in the home. You can't wait till later. The need for action is urgent. So in a sense, the court said, well, despite your objections, we have to override them because we say that if your mum was in a position to have, she did have capacity, she would have simply said, your views are very interesting, but I'm going to have the vaccine. And that's what the court concluded. Very briefly, if I can get it up for you, because this is even more recent. I prepared these slides on Friday, completed them, and then, would you believe, over the weekend, there was another case. So I'm going to try and upload this to you. Bear with me. May or may not work, but let's see what happens. Yeah, it's there.
Thank you. And share again.
No, I think it's all right. It's opening for me. Can you see it?
Yep.
Coming up. Yeah, raise CR.
Yep.
Yep. Okay, great. Again, so this is very, very recent, and this is also a relative who objects. This is what's interesting about this case. Sorry, just to explain briefly, that case I told you about someone who was in their 80s. There have been 2 or 3 other cases of people in the same age group where relatives have objected, but the decision has been virtually the same. So I haven't gone through those. What's significant about this case is that the service user was much younger. It was a man of 31 with learning disability, autism, and epilepsy, and was clinically vulnerable, as opposed to being clinically extremely vulnerable. But he was in the group for vaccination, priority group for vaccination. And again, we had a father objecting for a number of reasons. Again, fairly articulate reasons, just didn't want the vaccination. So the court said, look, in this case, the degree of disability is so severe that it's clear that he can't make any decision virtually about anything. He clearly doesn't have capacity. So what do we have to do? We have to put ourselves in the position of what would we decide if we were in his position but had capacity. And this is the way courts argue lots of these cases. Yes, you can take into account a relative's objection, but ultimately you have to decide for yourself. And the issue here is, which trumps which? Does the right to life trump a relative's views, or do we always go with the relative's views in cases like this? And not surprisingly, the court said right to life trumps it. So the court overruled the relative's objections and ordered the vaccination to go ahead. So that's interesting. That's where we're at in terms of the case law. You couldn't be more up to date. I'm sure you agree. So let's see if there are any questions.
There's one question from Kathleen, who is wondering how Brexit is likely to mean that there'll be changes to our governance by the Human Rights Act, maybe even abolition. And any views on that, Robert?
Well, I could get very angry at this point and say Brexit has nothing to do with the European Convention of Human Rights. And I would be absolutely appalled at any thought of any change in that situation. The answer to the question is, despite what politicians keep saying to you, Brexit, EU, and all those issues have absolutely nothing, categorically nothing to do with the European Convention on Human Rights. As I explained to you right at the beginning of the presentation, the European Convention on Human Rights has quite different genesis. It goes back to 1948, early 1950s. Most of it was formulated by British lawyers under Winston Churchill's leadership. It was ratified under Winston Churchill's government in 1953. The UK has always gone along with it. All that changed by the Human Rights Act in 1998 was you didn't have to exhaust all procedures in the UK and then go to the European Court. After 1998 Human Rights Act, it meant you could actually say to a UK court, look, the European Convention says this, therefore that's my right, and the UK court had to go along with that. If you're going to change that, what are you going to change? I don't know. The limitation of the Human Rights Act 98 from a social work perspective, and particularly adult care, is what I said earlier, is that if someone is in a care home which is run by a private or voluntary organisation or in a charity, they appear to lose their rights, especially rights to Article 8, because there's there's some seminal cases that go back to early 2000s, which say that if a home closes without sufficient consultation, then that's a prima facie breach of Article 8. But if it happens to be run by the Leonard Cheshire Homes, as happened in one case, the court said we've got no right to even adjudicate. We can't get involved. A home that's run privately can decide for itself. And there's a case, a Birmingham case, I think it's called YL in Birmingham, that says virtually the same. And we also then have the situation, the anomalous position, where if someone's care for is partly paid for by a local authority, but they're placed in a private or independent sector home, they appear to acquire rights under the European Convention, which they wouldn't have if they were self-funding. But I mean, I don't want to get into that because it's quite a complex issue, but there are some awful anomalies arising which weren't intended. But if you alter the Human Rights Act and say that actually public bodies no longer are accountable or no longer have to do that, all it means is we go back to the pre-1998 position, which means that people have to go through this laborious process of going through all the UK procedures, not being satisfied, and then going to the European Court. Yeah, thank you for reminding me of Winterwerp, 1979. If you look it up, it's a European Court decision.
Thank you. And Neil clarified the spelling there, so I'm sure that Wendy will be able to find it now. Fantastic.
Yeah, sorry, it's an Austrian case, so it's although it's called Winterwerp, it's spelled with a W.
It's okay. Now, there's one question from Hannah, who is wondering, as restrictions ease, do you think that changes will be revoked, or are we headed to increase remote assessments and working? And I guess generally, what does it mean for our profession and our skills base?
Right, how long have you got? I can't answer all those questions, but I mean, all I point out to you from a legal point of view is that incidentally, Winterwerp's not an Austrian case, it's a Dutch case, but never mind, it's the same rule that applies. Right, what I point out from a legal point of view is that the Coronavirus Act 2020, if you remember, there's a big debate about it. The government originally wanted it to be enforced for 2 years, but parliamentarians quite rightly said, no, we want what's called a sunset clause of 6 months. So after 6 months, you have to renew it, and that's the position we're now in. So the various regulations are coming up for renewal. All I can say to you is that the Coronavirus Act itself will eventually be rescinded. We have to go back to position prior to it, which presumably means you go back to practice as it was. But what's happened in the meantime is obviously a good question. And there are all sorts of issues raised. My personal view is the group that are really going to be affected most are our children. I think that's true generally, especially adolescents, but particularly in the context of social work, and particularly in the context of care proceedings. Some people are going to feel awfully aggrieved because they're going to lose their children on the grounds that a judge has decided at a virtual hearing that the significant harm has been caused, and then they can have, it's going to be quite difficult down the line, 3 years, 4 years in care, to argue against the inevitability of placement orders and so on and so forth. I think that there are some implications, but who knows? I mean, it's crystal ball time, isn't it?
Absolutely. Thank you for it, Robert. And Hannah just says it's really interesting to see what the future holds. Absolutely. I think what we're hearing from our local courts in the Bournemouth area is certainly that there is a view that remote or hybrid hearings will continue for the future because they are, in essence, cost and resource effective. Yes,
that's true. I mean, the other issue, of course, is delay and delay and delay. I mean, if a case of keeping delayed, it also has implications, doesn't it? But in terms of the convention, in terms of what the Children Act itself, actually, once the coronavirus regulations end, I think you'll find the President of the Family Court will withdraw their expectations that court hearings will be virtual. You can't really justify court hearings simply on the grounds of expediency and cost, you can't justify them being virtual on those grounds. Once that happens, and once you go back to the Children Act being the main consideration, then you must surely go back to live hearings with everyone in court, if people want it. That's their right. That's what Article 6 says.
Thank you for that, Robert. There aren't any further questions in the chat. Oh, there's one that just popped in. Where local authorities have stopped face-to-face visits in a case of child protection, where do they stand legally? That's a question.
Oh, good question. I would say where they stand legally, just about to fall down a big hole, I would have thought, because I can't. Difficult to justify that, isn't it? I mean, I can see how you can justify it in terms of, but there's been no amendment anywhere in terms of the statutory duty to investigate Section 47. I would say in a point of extreme vulnerability in terms of any legal action. My view. I think justified, isn't it? Yeah, I'm sure they have. Sorry, that says some local authorities have interpreted the guidance in this way.
Yeah.
Could I suggest that those local authorities go back and look at what the guidance actually says? And please bear in mind that unfortunately, this government has a tendency to say things in guidance that doesn't actually say in law.
And Sharon raises that we should be doing urgent emergency cases based on professional judgment, which I would agree on. And Jeannie raises that MCA assessments are being done virtually as well. So I think there's generally been a move towards undertaking virtual visits, virtual assessments, so on and so forth. And I guess that's where really the challenge for social workers is on an ethical and moral basis, as well as legal, because we all know that we've probably, well, certainly I have taken decisions that were legal, but probably not very ethical. Yeah,
I think that's absolutely right. And I think the kind of consolation I can offer you is if you actually take that view, then the human rights legislation generally, European Convention, is with you. But where the human rights laws are lacking is they never say anything about entitlement to services. They won't say that. What they will be about is assessment in the context of people losing their right to liberty and losing their right to look after their own children, so on and so forth.
Thank you for that. Richard's just raising about face-to-face visits in terms of Care Act assessments and Section 42.
Well, again, I mean, it's a professional issue. There's nothing illegal about doing a care assessment virtually, but I would have thought it does raise a whole load of professional practice issues.
Yeah, I guess most of the legislation really has been developed and brought into our practice when we didn't know that there was such thing as coronavirus in the first place, nor did we think that we could do visits or assessments virtually. I mean, we joked at the beginning that it's still a proud moment to be able to share a screen as a social worker. I certainly didn't even know what Zoom was about a year ago, and then I learned really quickly and very fast. And as a society and as a professional, we've made that shift to adjust and adapt to what this situation really required of us to do, maybe to some extent the bare minimum. But Sharon, you're pointing out what we need to really adhere to is our professional judgment, and that's based on our experience and expertise, and that's where probably for me good quality supervision comes in, and a good legal team that can help you to unpick moral and maybe legal issues if you feel that your local authority or your employer may be putting you in a position where you feel uncomfortable within your practice. So I would encourage people to check that. Now we're coming to the end of our session. There's some professional debate rather than questions in there. And Hannah agrees that supervision is essential, which is great. And what I would just like to do is thank you everyone for attending today on Social Work Day. What a brilliant way to celebrate, for me anyway, even if we're in the comfort of our own homes. Thank you again, Robert, for joining us today for
Pleasure.
this masterclass for the Teaching Partnership. It's been a pleasure. I hope you've learned a lot. I certainly have. We couldn't have been any more up to date than with case law from the weekend. So thank you for being so responsive and bringing that in. There is going to be a feedback form, as you would expect, that is going to be sent out to everyone who's participated today. It would be very, very helpful if you could fill that out, because that helps us to define if what we're doing is actually helpful, interesting, and what your learning has been. So, Louise, you're just pointing out it's been a good session. What is missing is the cake to celebrate World Social Work Day.
Yeah.
Absolutely, you're right.
Yeah,
so what I would suggest, without further ado, that you all have a nice lunch break, get some fresh air, maybe some rays of sunshine if you've got some. And I'm hoping to see you all very soon at the next masterclass or any other teaching partnership event or at Bournemouth University. So thank you all. I'm going to end the recording and the meeting now. But please feel free to get in contact with us if you've got any questions or queries or reflections that we should be aware of. Thank you very much and take care.
All right.